Good evening, everyone. Thank you so much for joining the annual review of Hong Kong health law conducted by the Center for Medical Ethics and Law of the University of Hong Kong. Good evening. I'm Gilberto Leung from the Faculty of Medicine of Hong Kong U. As you may know, CMEL, the center, was established jointly by the Faculty of Law and the Faculty of Medicine some time ago. And every year for the last 2 years, and this is the third one, we have this annual review to look at topics which are of interest to both legal scholars, legal practitioners, and healthcare professionals. And this year, we will have 3 talks to be delivered by 3 of our close colleagues and partners. I'll introduce them in a minute. And instead of turning this into 3 lectures, we hope that we will allow more time for discussions and question and answers. So the speakers would hopefully provide the basic background of the topic of choice, and we will have hopefully a more interactive experience this evening. Right. And also, sorry that I forgot to say hello to those who are online. I know we have over 500 registrants. Some of them are here, many of them are online. So let's begin. Our first session, it's going to be delivered by Ms. Bianca Wu, who is Senior Associate from House Williams, very important major law firms in Hong Kong, looking after our healthcare professionals, among other things. And she's going to talk about informed consent with respect to the recent case of McCulloch in the UK. So Bianca, over to you. Thank you.
Thank you very much for having me here today. I'm speaking in place of my partner, David Khan, who extends his apologies that he cannot be here today due to an emergency. But then I hope that I can give my 2 cents, and I hope that that will be of value to this discussion. Now, I'll be presenting on McCulloch, which is a recent case. You can see the background there, and I don't propose to go into it in any detail. We cannot understand McCulloch without understanding the law on informed consent. There are 2 very important cases when it comes to understanding consent, and that is the Bolam test, the Bolam case, which is the responsible body of medical opinion. And that is the standard to which a doctor would be judged traditionally in a case of informed consent. Now, that's the traditional test. And in 2015, the pendulum swung the other way in the case of Montgomery. Montgomery is a Scottish decision. And basically what they have changed is the test on disclosure of risks to being a test of materiality, i.e. whether the risk is material to the patient or a reasonable patient in that patient's position. So it's the objective and subjective materiality test. So you can see that there is a very significant change. And one question that still remains relatively unclear is whether this test of materiality extends to deciding what are reasonable treatment options. That question is now answered by the case of McCulloch. Now, McCulloch, as you can see, is actually essentially a diagnostic case. Mr. McCulloch presented with symptoms of pericarditis, suspected pericarditis. But he underwent an echocardiogram, and the findings did not seem to meet the diagnostic criteria. So there were 2 admissions, and the key admission was the second one, where he underwent a repeat echocardiogram. Now, he was seen again by the same cardiologist, and during that, she found that the findings were comparable to before. It was similar. And also, Mr. McCulloch denied that he had any symptoms. So he said, I have no chest pain, no palpitations, and other symptoms of pericarditis. The cardiologist did not advise NSAIDs because there was no complaint of chest pain, essentially. She did not think it was clinically indicated, and also the diagnosis of pericarditis remained uncertain. So Mr. McCulloch was discharged. Lo and behold, Mr. McCulloch suffered from a cardiac arrest, and sadly, he passed away. The diagnosis turned out to be idiopathic pericarditis and pericardial effusion. Now, the case went all the way up to the Supreme Court, and the unanimous decision amongst all three courts is that they were in favor of the doctor, the defense. The lower courts agreed that in deciding what is a reasonable treatment option, the professional practice test applies, i.e. the Bolam test applies. But since the patient's presentation was atypical, there was no indication for NSAIDs, and there was no need to advise him of this treatment option because it was not a reasonable treatment option based on the expert evidence. So that's the professional practice test applied. Now, the appellant persisted, went all the way up to the Supreme Court, and he argued the duty to advise reasonable treatment options cannot be based on the Bolam test. It has to be unshackled from Bolam. It must be referring to the individual patient. The main argument that they put forward is that if a doctor, if the reasonable treatment option is purely decided by the doctor based on his clinical judgment, this would severely reduce the available options to the patient. And what if the patient wanted a treatment that he or she feels is appropriate to him or her, but the doctor doesn't explain it? So the appellants argued that the Montgomery test on materiality should be applying to deciding reasonable treatment options. Now, the respondents, they fired back. They say that what is reasonable is what is clinically appropriate. And the only people who can decide what is clinically appropriate has to be the doctor who has the unique skill and the expertise to decide on a reasonable treatment option. Therefore, they contended that the Montgomery test did not apply to the reasonable treatment option assessment. The appeal failed. As I said, it was a unanimous decision on all fronts. And what I want to point out is that is highlighted in bold and underlined is that the narrowing down from possible alternative treatment options to reasonable treatment options is an exercise of clinical judgment, i.e. the Bolam test applies. And the upshot of the court's decision, the Supreme Court's decision, is that by filtering down to the reasonable options, you will not be bombarding the patient with everything under the sun, because that could not possibly be in the patient's interests. Now, you see that the Supreme Court has set out a number of reasons to justify their decision. One that I found quite interesting is that they say that McCulloch is actually wholly consistent with Montgomery, Deuce, which is another UK decision, and the General Medical Council and the British Medical Council's guidance. Now, in Montgomery, what they have held, and I'm going to read out from their judgment, what they held is that a doctor is therefore under a duty to take reasonable care to ensure that the patient is aware of any material risks involved in any recommended treatment and of any reasonable alternative or variant treatments. So it's already recognized in Montgomery that only reasonable treatment options can be explained. It is clarified in McCulloch that what is reasonable is for a doctor to decide based on the clinical judgment. Okay, so it's not contradictory to Montgomery. I agree, it's consistent. With Deuce, Deuce is also a very important case. It was quoted in McCulloch. Deuce basically introduced a two-stage test when it comes to giving a consent explanation. The first is that there's a diagnosis and there's the treatment options. The second is the disclosure of the risks. In Deuce, it was decided that the knowledge of the risks and everything before the treatment, the diagnosis, the treatment options, that is for the professional, the doctor. In the second stage, the disclosure of the risks, that is more patient-centric. Okay, so Deuce is essentially a foundation, if you will, that led to McCulloch, and then McCulloch reinforced that two-stage test. And with the GMC were they were the interveners in the Supreme Court appeal. Now, whilst they emphasized that they really welcome Montgomery, they say that patient autonomy and self-determination is a very important principle, but they also firmly argued that when it comes to diagnosis and treatment, that is a matter of clinical skill and judgment, and which is really for the doctor to decide. So that's consistent with those. Now, McCulloch seems to be a very significant and a very sudden change, but actually I don't think it's all that sudden. I'm not all that surprised when I look back at some of the cases leading up to McCulloch. There are a number of case authorities that actually hinted that we are heading towards McCulloch. And I would like to draw your attention to Airedale. The principle of proper medical treatment can only be treatment that is in the public interest. And if you introduce a treatment that is not proper, that is not in the public interest, you cannot possibly get the patient's consent for that because it's not appropriate in the first place. So that is kind of the overriding principle that I think permeates in McCulloch as well. And as you can see, there are other cases that swing back to patient autonomy. I'd like to call this the tug of war between medical paternalism and patient autonomy. But there was a bit of swinging to and fro. And if you look at Burke, I think this is a very important case that talks about sort of the limitations when it comes to the self-determination principle in informed consent. Now, just because a patient demands treatment, it doesn't mean that it's an appropriate treatment, and it doesn't mean the doctor has to perform that treatment. Their legal obligation cannot be as such just because the patient demands it. I think that in that case, if a doctor proposes inappropriate treatment and then performs it, it's actually a very dangerous situation. So that was in the case of Burke. And as I said, Montgomery was also still very unclear as to what the test would be when it comes to determining reasonable treatment options. There are cases as well that try to adopt a more hybrid approach. So in the case of Britain, in that case, the court suggested that it could be for the medical expert and the patient. It's a hybrid decision, not just for the doctor based on the professional practice test. You could see that thinking also being shown in the case of Bailey. So the court should decide reasonableness based on a holistic approach. And also in Taylor, discussing the options and risks as a mixture of professional judgment and patient autonomy. Now, this is the hybrid approach that was entertained for a while, but I think the case law is now settled as seen in DUCE, as seen in AH, as you can see above in the slide, and now in McCulloch, that really who decides what is reasonable should be for the doctor. Now that we know that in McCulloch, it's the doctors who decides what is reasonable, i.e. what is clinically appropriate, how does that translate to practice? So this is something that me and David have been discussing when we discuss this case. What if there are multiple treatment options? They might seem reasonable, they could be applied to this patient, but they are also controversial. For example, unorthodox options, options that have never been medically tested for a condition, but it's still open as to whether it could be tested. It's the only option left. Would that option be proposed? Would that option be even disclosed or discussed? How far would you discuss that option? I think there is yet to be seen what qualifications or guidance there would be post-McCulloch. Catch-22 situations is, I would be thinking of the pre-morbid patient, a patient with many comorbidities who might get treatment A, but this could cause problems to a certain condition. And that would lead to possibly more problems than good, but then you would be resolving an acute situation. So in that scenario, how would you explain the reasonable treatment options? So these are some food for thought. Now, what if the treatment is not available then? In Montgomery, there was some discussion as to the bureaucratic factors. So say you think a treatment is reasonable and possibly it might be preferred by the patient, but it's not available at your hospital. Well, the law seems to say that if it's available elsewhere, you should really explain it because it's accessible. But what does it mean by elsewhere? In a different hospital? In a different country? How far would you be able to go to discharge your duty? And the patient's priorities in assessing reasonableness, can they truly be ignored when filtering the possible treatment options to reasonable treatment options? This was briefly explored in McCulloch at the end of the judgment. You can have a patient who is very interested in what kind of treatments there are, even the ones that may not be appropriate. And you've got someone who's disinterested, who doesn't care. I just want the doctor to tell me what to do. Well, it seems that in McCulloch, there is no qualification for that kind of scenario yet, because that wasn't the case with Mr. McCulloch. The position seems to be that you just have to explain all reasonable options, provided that you have gone through the exercise of filtering them from possible treatment options. And lastly, ultimately, if a case goes to litigation, ultimately it's the court's decision to decide which side to take. So you can't say that the court has no part to play, especially if it goes to litigation. Now, here are some of my final thoughts, and I welcome any questions and discussion points. I do think that McCulloch is a landmark decision, despite that there has been a foundation in the past. I think it does level the playing field. It clearly defines the boundaries now between the first and the second stage of getting informed consent. I do think that it is a matter of clinical judgment for the doctor to filter out the reasonable options, and it affirms and clarifies Montgomery. As I said before, it's the reasonable treatment option concept has already existed in Montgomery, and this further seeks to clarify it. And it's all in well that it steers away from defensive medicine, and it is reassuring to doctors because of the clearly defined boundaries now. But I discussed this with David. Well, how else would it be? The only logical conclusion, I think, is that the doctor must decide what is reasonable, because precisely because they are the experts in this field, precisely because they have the unique skills and knowledge to carry out this exercise. And if they think that something is not reasonable, why should they explain it? They shouldn't introduce something that would only bombard the patient and confuse them. So that to me actually echoes a very fundamental medical ethical principle. Now, another just a small comment is that when you look at the case of McCulloch, and it ends up being an informed consent case, I would think that just looking at the facts, it's more of a diagnostic case. I would defend it on the basis that, well, the patient did not meet the diagnostic criteria of pericarditis, and therefore he didn't improperly miss any diagnosis. He wasn't, he's not meant to be coming to that diagnosis in the first place, and therefore the treatment of NSAIDs would not apply in the first place. So it's more like a diagnostic type of defense rather than informed consent, which I believe would be possibly easier to defend, given the atypical presentation. Now, lastly, the medical council, they have anticipated Montgomery in the past. They saw the evolution of cases and they thought Montgomery makes sense. And they have incorporated the principles of Montgomery primarily in surgical cases. But now we've got McCulloch, and McCulloch was decided based on clinical assessment. It was a non-invasive scenario. So the question is, are we going to be applying this one standard in all cases, including non-clinical cases? Would that be too burdensome on the doctor? Possibly, but I cannot see, and I'm not aware of any qualification to this test yet. I think this remains yet to be seen in post-McCulloch. So in summary, reasonableness is guided by the clinical appropriateness of the treatment option after filtering from possible options, and this is still a matter of clinical judgment and to be judged by the professional practice test. I believe McCulloch would be welcome in Hong Kong. I cannot find a case where it's been applied, but I think it's going to be welcome. Note that it's not binding, but highly persuasive. And I would really encourage you to read the judgment. I think it's fascinating, the arguments that were made on both sides from the GMC, the court's sort of reasoning, why they rejected certain arguments and how they interpreted Montgomery and Deuce. I think it's very worth reading. And I would also encourage you to read the learned article from Professor Leung, which is also a very, very insightful. With that, thank you very much for having me today. I'm just looking at the time, and I welcome any questions. Thank you.
So much, Bianca. Just want to correct you that if you have read the judgment, you don't need to read my editorial. It will be unnecessary. But thank you so much for that very, very insightful sharing. So our next presentation is to be given by Ms. Sandy Cho, a partner of Kennedy's, another very important law firm that looks after healthcare professionals. She's going to talk about the liability to family and loved ones of patients for psychiatric injury caused by witnessing death or medical crisis in a clinical setting, which is a very long-standing problem in tort law. The case that Sandy is going to talk about is for another and Royal Wolverhampton NHS Trust. Thank you, Sandy.
Thank you, Professor Leung. Good evening, everyone. My name is Sandy. I'm a partner of Kennedy's Hong Kong. Kennedy's is a global international firm. So tonight I'm presenting about the case called Paul and Royal Wolverhampton NHS Trust. I'm not sure whether all of you have the chance to read this judgment because it is over 70 pages. And let me help you to just have a digest of the case. It is always good to start with some basic principles. So let's start with the general rule, because I'm conscious that maybe some of you may not be studying or practicing in law. So the general rule is that the doctor owes a duty to his patient to exercise reasonable skill and care in providing management. And the doctor will be liable to any harm caused to his patient, which was the result of his own negligence, management, or advice. And the doctor should compensate the patient for any loss or harm, or compensate the dependents of the patients in case of any of the death of the patient. So in this case, the patient or the executor or administrator of the patient, in the case of the death of the patient, can sue the doctor or the health authority for damages. And we call this patient and the executor or administrator as the primary victim. And in some very limited cases, the common law also recognizes the duty of care being extended to another person who witnesses an accident or its immediate aftermath, in which their loved ones sustain fatal or physical injuries caused by the negligent act of the tortfeasor and suffering psychiatric injury. This claimant is not directly involved in the accident, but suffer from a psychiatric injury by witnessing the accident, injuring the primary victim. And this victim, we call them secondary victim, may also have a potential claim against the tortfeasor. So this is the general position. So before I discuss about the English case, maybe it is also good for you to know what is the position in Hong Kong. In Hong Kong, the authority is set by Li Wah, and also in this Li Wah case, it has referred to Wong Fong Wui, another case in the district court, and also 3 House of Lords cases decided in UK. And in these 3 House of Lords cases, it set out the 3 elements for which a secondary victim claim have to meet in order to succeed. For the first criteria, it is the relationship between the primary victim and the second victim has to be sufficiently proximate as to be within the class of person whose claim should be recognized. And for the second criteria, it requires that the plaintiff has to show propinquity in time and space to the accident. That means it has to be close enough, proximal enough in time and space to the accident itself. And lastly, the psychiatric condition must result from the short taken through sight or hearing of the event or its immediate aftermath. Li Wah is not a medical case, so I am not going to bother you with the facts of the case. It is actually a running down case. So now we are going to the case we are going to discuss tonight, Paul and Royal Wolverhampton NHS Trust. The critical questions the Supreme Court has to decide in this case is whether a doctor, in providing medical services to a patient, it does not only owe a duty to the patient to take care, to protect the patient from harm, but also owes a duty to close members of the patient's family to take care and protect them against a risk of injury that they might suffer from the experience of witnessing the death or injury of their relative from an illness which was caused by the doctor's negligence. So this is the gist of the whole case. I'm sorry that I have to bombard you with some facts matrix of this case, because this Supreme Court case is not one case. It is actually a conjoined appeal of 3 cases, 3 medical negligence cases. In the first case, Paul and Royal Wolverhampton NHS Trust, it involved 2 daughters' claimants witnessing their father's cardiac arrest, and the father was declared dead upon arrival at the hospital. The 2 daughters' claimants thereby sustained psychiatric injuries after witnessing the father's cardiac arrest. It is alleged that the doctor failed to arrange a coronary angiography, which could discover the heart disease, and treated it accordingly when the disease was admitted to the hospital around 40 months earlier. And in the second case, Cormier versus Royal Cornwall Hospitals NHS Trust, it involved a 6-year-old disease, and he had a history of shortness of breath, appearing pale, and turning blue. The parents' claimants saw the failed resuscitation on the disease and the eventual death when she arrived at the hospital by ambulance. Again, the parents claim sustained psychiatric injuries by witnessing the death of the son. And around 6 months before the death, it is alleged that the pediatrician has wrongly diagnosed the disease with exception instead of pulmonary vein occlusive disease and failed to treat it. In the last case, Purchase and Ahmed, the mother claimant came home and found her motionless daughter soon after her death. When the mother attempted mouth-to-mouth resuscitation, the blood and bodily fluids spilled out of her mouth and nose, which is a very scary experience for the mother. And after that, the mother also listened to a voice message from the daughter around 4 minutes, which recorded her dying breaths. All this caused the mother to suffer very severe psychiatric injuries after the daughter's death. And it is alleged that the GP, the general practitioner, failed to diagnose the disease severe pneumonia when she presented to the clinic earlier. In this Supreme Court case, actually, all the justices have agreed that the requirements for secondary victim claims have been clearly set out in the Free House of Lords decision, which I have referred to in the Hong Kong Authority. In the Hong Kong Authority, Li Hua, they are also referring to the same Free House of Lords decisions. They are namely McLaughlin, Alcott, and Frost. In McLaughlin, the first case, the claimant saw her husband and kids at the hospital 2 hours after the accident, and in the same condition as they would have been at the roadside, being covered with mud and oil. And the immediate aftermath was extended to cover the claim site of the victims at the hospital. Thereby, the claim was allowed in McLaughlin. And in the other 2 cases, Alcock and Frost, they arose out of the same disaster in which 95 people crushed to death and over 400 people severely injured as a result of the overcrowding in the Hillsborough football stadium. All these 3 cases involve injuries to primary victims sustaining injuries in an accident. The Supreme Court justices in this case agree that Alcott and McLaughlin emphasized the need to set limits to secondary victim claims based on the concept of proximity and recognize the limits are influenced by practical and policy consideration. The task of the Supreme Court in this case is to decide whether and how what was decided in these 3 leading cases also apply in the case where event witnessed by the claimant is not an accident, but a series of events or sufferings of their close family member. And in doing so, they have reviewed a number of earlier authorities and sought out the inconsistency in these authorities in order to find out the required factors of proximity and also lay out the requirement for limiting the secondary victim claims. And all 3 claimants in this Supreme Court decision, as I explained earlier, it was not about accident, but were about claiming damages for psychiatric injuries after witnessing the death of the family due to the NHS doctors' failure to diagnose or treat their family. So in the following decision reviewing of the authorities, the court have also reviewed some cases about medical negligence cases. There are a number of those authorities, and all these authorities give very inconsistent decisions. In the first case, Taylor Somerset Health Authority, the patient suffered heart attack at work due to the defendant's failure to diagnose a heart disease. His wife arrived at the hospital within an hour and was informed of the death and saw his body in the mortuary. The claim failed for 2 reasons. First, there was no external traumatic event in the nature of an accident or violent happening. Rather, the death was the culmination of the natural progress of the heart disease. Also, the doctor's explanation to the wife or her sight of the deceased body at the mortuary was not coming within the aftermath as recognized as McLaughlin. Therefore, the case failed. And in the second case, Sont and Hampstead Health Authority, the defendants negligently failed to diagnose the patient's bleeding in his kidney and leading to his gradual deterioration and death in 14 days. The patient's father witnessed the gradual deterioration and the son's death and sued the authority for psychiatric illnesses suffered by him. Again, the claim was failed, and the reason for this being failed is the claimant failed to prove there was any sudden shock in the scenario. Later, in 2002, there was a case called North Groningen NHS Trust and Waters. In this case, due to the misdiagnosis of the doctor, an infant experienced seizure, suffered brain injury, and died in 36 hours in the arms of his mother. And the mother thereby suffered psychiatric illness and sued the trust. The court found that all the events, namely seizures, coma, and withdrawal from the life machine, were actually one drawn-out experience, and thereby allowing the claim. Later in 2003, another decision deriving from Waters is that a mother only saw the daughter's body at the mortuary 2 hours after the traffic accident, but not at the accident scene. In this case, the court found that the immediate aftermath continued until the claimant saw the body, and therefore distinguished the Alcott decision and decided the mortuary visit was not only an identifier of the body, but to complete the whole story, and therefore allow the claim. And later in 2013, in Taylor and Novo, in another case, the wrecking balls fell on the victim's head, and she suddenly died 3 weeks later of pulmonary embolism, resulting from a deep vein thrombosis due to previous injuries sustained at the accident. Her daughter did not witness the accident, which was a separate incident or event in time from the death, and she only witnessed the death. The claim was therefore failed. And in 2015, there are 2 other medical cases whereby both of the claims failed. In the first case, the patient's brain scans were not properly assessed by the doctor, and she was released from the hospital. She died subsequently from a subarachnoid hemorrhage caused by an aneurysm in the cerebral artery. The court found that there was no seamless single horrifying event, therefore failed the claim of the claimant. All the events was actually over a period of time and was not horrifying at all. And in other NHS case, also decided in 2015, the patient was readmitted to hospital for hysterectomy due to the defendant's negligence. Her husband saw her after an emergency surgery when her limbs and face were very swollen, and he suffered psychiatric injuries and claimed damages against the trust. Again, the court found that there was no seamless tale as in Waters. Rather, it was only a series of events giving rise to an accumulation of gradual assaults on the claimant's mind as he realized his wife was in danger. And actually, there was no sudden or unexpected incident, but seeing his wife before or after the operation. And there was also no horrifying events by any objective standards. Therefore, he failed the claim. So, as you can see from all these cases, the court either failed the claim by saying there was no horrifying event in medical negligence cases, or there was no climax, no sudden event, no traumatic event, but there was no discussion or detailed analysis of what should attribute as an event, and whether or not witnessing a medical incident or negligent medical treatment should sufficient for the requirement as set down for accident cases. One of the requirement, which is not disputed and is not an issue of the of this Supreme Court decision is that all these three cases, the court find that actually there was a close tie of love and affection with the deceased. And by finding that, the court has referred to the earlier leading cases, Alcott and Flost. In Alcott, the claimants who lost their brothers and also brother-in-law in a very severely overcrowded football stadium had no presumption of close tie of love and affection with the deceased. And this had not been proved by evidence there was any close tie of love and affection. Therefore, there was no presumption that the brother and the brother-in-law are in close enough or proximate enough in order to recognize as the parties which can claim damages against the defendant. However, such ties can be as presumed in cases where the spouses witnessing the other spouse injury or death, or from between the parents and child situation. And in another case, in the case of Floss, the police officer who were present at the same disaster also was found to have no close tie of love and affection with those killed or injured in the stadium. So in the Supreme Court decision, actually it has affirmed that if the claimant is not the parent, child, or spouse of the patient, they will have to prove the close relationship by evidence instead by presumption. However, the Supreme Court justice has also referred to one of the judges' judgment in Alcott and suggest that there is no need to draw any line between spouse or other family member, as long as they can be proved that they are close enough and proximate enough, and there was evidence to show the close tie, they should be eligible to claim damages. Instead of proving only the marital status or parental status, the court is required that the evidence should be shown or to adduce evidence to support that there's any close tie between family members or close members of the family. So the focus of the Supreme Court decision is still in the second limb, proximity or propinquity in time and space to the accident. However, as I explained earlier, all the cases have very conflicting decision or outcome. And the Supreme Court has also made some comments in regarding those cases and decision. In the first case, Taylor, the court find actually that this case is correctly decided and follow the Free House of Lords decision and the limits, which limiting the secondary victim claim by allowing only claims when there was an external and traumatic event in the nature of accident or violence happening. And also it restrict that the doctor's explanation to the claimant and also the claimant's sight of the deceased body does not fall within the aftermath as recognized in McLaughlin. However, in the second case, the court find that although the decision was correctly made, it was made on a wrong basis because the claimant in this case, in this medical negligence case, did not witness an accident or any aftermath caused by the defendant's negligence, and therefore there's no need to consider any sudden shock in this case. In the other two cases, Waters, and also the other case which derived from Waters, actually the Supreme Court decided that both cases are wrongly decided because the damages should not have been awarded since the brain damage and death, which were not caused by an accident, but caused by a series of events. And also by allowing the damages, it has unsatisfactorily developed the legal test of whether the claimant witness should be regarded as one event or separate several events. In the second case, it also decided that the extension of the aftermath should not be allowed because the McLaughlin cautious approach should be adopted and upheld. For the last case, for the third case, Novo, Taylor and Novo, the court find this case actually was decided on correctly because there were actually two separate events about the falling boards hurting the victim and also the subsequent death of the primary victim due to the deep vein thrombosis. And because the daughter did not witness the accident itself or its immediate aftermath, the claim has to be filed. In the last two cases decided in 2015, again, the Supreme Court find that both cases were correctly decided, but again, on the wrong basis, because there were no accident. The claimant did not witness any accident or its aftermath caused by the defendant's negligence, and there was no need to consider any sudden shock or horrifying event. And in order, if we are to impose any sudden shock or horrifying event in these medical negligence cases, the Supreme Court considered it would push the judges to compare the facts of the case before them with the facts of other cases and engage in an exercise of deciding whether or not the facts are similarly horrifying or which is more horrifying and less horrifying. So this is a very unsatisfactory exercise, factual finding exercise. So in conclusion of after reviewing all this inconsistent decision, the Supreme Court actually found that it is a must to distinguish between an accident and medical crisis. And it defined accident as an unexpected and unintended event which caused injury. Occurrence or manifestation of injury is not part of what defines the accident. Therefore, only witnessing the manifestation of the injury or suffering is not enough, and because it did not constitute to an accident. Medical crisis, instead, is some suffering or death of the primary victim, and therefore, it is not something which is sudden or traumatic. And also, the length of time for which the symptoms of injury or disease last before the recovery or death can vary from cases to cases. It can be a few days or even a few months. So it will cause uncertainty as to what qualifies as an event. Also, the extent of the claimant's traumatic experience can vary, and none of the criteria of sudden shock, horrifying event, or first manifestation of damage should be an acceptable test to be adopted. In this Supreme Court case, actually the court is not being asked to abrogate or alter the requirement as set out in the House of Lords decision. Instead, the Supreme Court is being asked to draw or recognize an analogous of cases where illness sustained by witnessing a death or manifestation of injury without an external traumatic event, but as a result of a pre-existing injury or disease. However, the Supreme Court decided that it is not reasonable to make any analogy between those cases which the secondary victim is witnessing an accident and situation where the claimant does not witness an accident, but only witnessing the suffering or illnesses as a result of a medical crisis. So the implication of this is that the Supreme Court decided that a patient's death due to a doctor or hospital's negligent failure to diagnose or treat is a medical crisis, but not an accident. And in a situation where the family only saw the patient hours after an initial accident, or over a period of time, or across some events of suffering, the extension of immediate aftermath exception would only be allowed in limited circumstances, as in McLaughlin. In the causation limb, actually, the court has relaxed this limb a little bit by saying that you have not to prove sudden shock or horrifying event. And as long as the experts say that the claimant, the secondary victim, has suffered some recognized psychiatric illness, then there should be a causal connection between witnessing the event and also the injury suffered. And the Supreme Court also made comment that in engrafting onto those requirements, any additional requirements of needing to prove the claimant's injury was caused by the mechanism of a sudden shock to the nervous system was a sufficiently horrifying event is an unfortunate wrong turn. And therefore, it disapproved getting those additional requirements into the originally requirements. So the causal limb has actually been released. Finally, the court has also tried to apply the general principles which govern the existence or scopes of duty of care owned by medical practitioner in order to test whether the decision or the comments, the findings he has made in reviewing all those early inconsistent authorities can stand. And it has decided that in favor of all the defendants and dismiss the appeal and find that there's actually no general duty of care owned by doctors to close family of patients. The reasons being that the responsibilities of a doctor or medical practitioner does not extend to protecting the members of the patient's close family from exposure to any traumatic experience of witnessing the death or manifestation of disease or injury in their relatives. And if to impose such a responsibility on the hospital or doctors, it actually goes beyond what is reasonably regarded as the nature and scope of the doctor's daily role and duty. And therefore, for policy reason, it is also undesirable to overcomplicate some end-of-life care decisions when the hospital must be exposed to potential legal liability to family members if it is said that death ought to be prevented. So for this reason, all three cases are being dismissed. So what is the implication to the doctors in Hong Kong? As similar to other Supreme Court cases, although it is not strictly applicable or binding to Hong Kong court, it is highly persuasive. So if there is another similar, another case with similar set of facts going to the court in Hong Kong, I'm sure that the court will also allow or follow the UK position in establishing the legal requirements. Namely, there must be close ties of love and affection, and only those parental and marital relationship can have the presumption. Otherwise, it has to be proved by evidence. And secondly, then the victim must directly perceive the accident or its immediate aftermath. So it has actually tightened the proximity test. And lastly, it must be an unexpected and unintended event caused the psychiatric injury. It do not have to prove any sudden shock or horrifying event. In the judgment, the judge also open questions and give a hypothetical example and suggest that whether or not the rules governing claims by second victim arising from accident could ever apply in medical setting. And also suggest that for some hypothetical examples, like a doctor injecting a patient with a wrong dose or wrong medication, wrong drug, and inducing an acute adverse reaction, which is witnessed by a close relative, whether or not it would attract any liability to the secondary victim, which is a close family member of the primary victim. And the court actually say that the issue raised by these examples should be best left to be addressed in a case which actually arise on the facts. therefore it declines to make any further comments on the case. But I believe that there should be some scenarios which is very similar to accident cases, like what we do in orthopedic therapy or physiotherapy. Sometimes from time to time, there must be some accident happened. And in those cases, I'm sure that those rules governing accident cases for secondary victims would also apply to those cases. So this is all from me for the case of Paul and Wolverhampton NHS Trust.
Thank you so much, Sandy. Our third presentation is going to be delivered by Ms. Jane Orr, who is our research manager at the Center for Medical Ethics and Law.
Hi, everyone. In this presentation, I will focus on 3 developments in Hong Kong. I'll change the order a bit and I'll talk about 2 manslaughter cases against doctors first, and then a professional misconduct case in which a family medicine doctor, without proper care and assessment, certified a patient's mental fitness for making judgment of the patient's own finance. I'll talk about the third item first, and then the first item. Lastly, I will talk about the second item here on my slide, which is a piece of new legislation called the Advanced Decision on Life-Sustaining Treatment Ordinance. I'll talk about developments in 2 Hong Kong manslaughter cases against doctors. The first case concerned the death of a patient called Tang Kwai Si, who was a hepatitis B carrier. In 2017, when the patient Tang Kwai Si was treated with high-dose steroid for a kidney condition, 2 hospital authority doctors failed to prescribe anti-hepatitis B medicine for her so as to reduce the risk of hepatitis reactivation and potential development of liver failure, even though the patient's medical history of being hepatitis B surface antigen positive was actually documented in the medical records of the hospital. The patient was later found to have a hepatitis B flare and subsequently died. For disciplinary proceedings, the 2 doctors were found guilty of misconduct in a professional respect by the inquiry panel of the Medical Council. As for the sentence, the inquiry panel ordered that the name of one of the 2 doctors be removed from General Register for 5 months, with operation of the removal order suspended for 36 months, and that the name of the other doctor be removed from General Register for 3 months, with operation of the removal order suspended for 18 months. As for criminal prosecution, in early 2023, the 2 doctors were each charged with 1 count of manslaughter over the death of the patient. In mid-2023, after careful consideration of the prosecution code, the prosecution told the court that the manslaughter charges fell short of criminal prosecution standards and withdrew the manslaughter charges. In 2024, in the coroner's court, the jury ruled that the patient died of misadventure and made 5 recommendations to the hospital authority. Let's have a look at the jury's 5 recommendations to the hospital authority. First of all, the hospital authority was recommended to categorize patients on large doses of steroids for less than 7 days as high risk too, and to make sure they were also given antiviral drugs. Secondly, it was recommended that hepatitis B carriers, even those without symptoms, should be considered for subsidized regular checkups at private clinics. Thirdly, it was recommended that hospitals should teach patients to be on the alert for symptoms of hepatitis B. The 4th recommendation was that doctors should keep clear, legible records that could be easily understood by other doctors. The 5th recommendation was that hospital laboratories should have to explain the reasons for cancellations of tests. It is hoped that these measures will be helpful in preventing tragedies of this kind from happening again. The other manslaughter case that I would like to discuss is HKSAR and Kwan Hao Chi Vanessa. In this case, a patient died after a doctor performed a liposuction procedure on her. In 2021, the doctor was convicted of manslaughter by gross negligence and sentenced to 6 years imprisonment. The judge sentenced the defendant on the basis that the defendant had breached her duty of care by failing to ensure the presence of a properly qualified person to administer and monitor sedation, to ensure sufficient oxygen supply, to follow the guidelines on procedural sedation of the Hong Kong Academy of Medicine, to provide proper and sufficient monitoring after the liposuction procedure, and to provide adequate timely resuscitation. In 2023, the Court of Appeal decided on the doctor's application for leave to appeal against conviction and sentence. In relation to the doctor's application for leave to appeal against conviction, the Court of Appeal noted that a key factor in this case was that the nature of the deceased's death was unable to be ascertained, and that it was arguable that the medical experts proposed a cause of death of which they were uncertain. The Court of Appeal held that ground 4 and grounds 6 to 10 advanced by the doctor were reasonably arguable, and that ground 5 advanced by the doctor was reasonably arguable too, but only to the extent specified in the reasons for judgment. Hence, the Court of Appeal granted the doctor leave to appeal against conviction. In relation to the doctor's application for leave to appeal against sentence, the Court of Appeal held that both grounds of appeal against sentence advanced by the doctor were reasonably arguable. Hence, the Court of Appeal granted the doctor leave to appeal against sentence too. Our center will report on developments concerning the appeal in our center's newsletters. If you are interested in subscribing to our center's bi-monthly newsletters for free, please fill out the subscription form on our center's website. I'm going to talk about our medical council inquiry panel case. In this case, a patient had been suffering from Alzheimer's disease with treatment of medications from the Department of Psychiatry of the Hospital Authority since 2014. In 2015, the patient, who was then 86 years old, attended for the first time the clinic of the defendant's doctor, who was not a psychiatrist, but a specialist in family medicine. After the very first consultation by the patient, the family medicine doctor issued a medical certificate which certified, among other things, that the patient was mentally fit for making judgment of her own finance. The charge of professional misconduct against the family medicine doctor in this case was that he, without proper care and or assessment, issued a medical certificate which certified that the patient was mentally fit for making judgment of her own finance. The key issue was whether the certificate regarding mental fitness was issued by the family medicine doctor with or without proper care and assessment. Importantly, it was the very first time that the 86-year-old patient attended the clinic of the defendant's doctor, who was a specialist in family medicine rather than a psychiatrist. The patient claimed to the family medicine doctor that she had no history of cognitive or psychiatric dysfunction. The doctor had no knowledge about the patient's psychiatric history at the hospital authority. The doctor also did not have access to the patient's medical records at the hospital authority. After the doctor's assessment during the patient's first visit to his clinic, the doctor was of the opinion that the patient was oriented to time, place, and person, and that the patient understood the reason of attendance at the clinic, which was for financial management authorization involving transfer of property ownership and the follow-up plan of finance by herself and her son afterwards. During that visit, the doctor conducted a mini mental state examination, MMSE. MMSE is an instrument for cognitive function assessment. The patient got a score of 18 out of 30 in the MMSE. After this very first consultation, as mentioned, the doctor issued a medical certificate which stated that the patient was mentally fit for making judgment of her own finance. The inquiry panel found that the doctor issued the mental fitness certificate without proper care and assessment. Let's look at the reasoning of the inquiry panel. The inquiry panel held that the test carried out by the defendant's doctor, namely mini mental state examination, MMSE, is only a screening test for cognitive function, and that one has to approach the results of MMSE with caution, which are not conclusive as to the mental capacity of the subject patient. This is particularly true when the score is within a low range of 18 to 20 out of 30. The patient in this case had a score of only 18 out of 30 for MMSE. The inquiry panel accepted that patients with a score of 18 out of 30 have an 80% probability of suffering from dementia, and observed that the score of MMSE alone cannot confirm the presence of satisfactory capacity or lacking of it. The inquiry panel also held that although the patient denied having any illness affecting her memory, a reasonable doctor should know that the medical history from the patient would be unreliable because her memory was impaired, as suggested by the low score in the memory test during the MMSE. And this was the first ever consultation by the patient to the defendant's doctor. The defendant's doctor should not rush into signing a certificate before full and proper medical information was obtained. The inquiry panel noted that the defendant's doctor had not obtained information about the patient's contemporaneous financial situation and her ability in managing her finance. Lastly, the inquiry panel held that the particular poor results relating to subtraction and recent memory, coupled with the borderline score of 18 out of 30 in MMSE, called for further medical and social information from the patient and or her family before the defendant would be in a position to certify that the patient was mentally fit for making judgment of her own finance. For these reasons, the inquiry panel held that the defendant issued the medical certificate in respect of the patient's fitness for making judgment of her own finance without proper care and assessment. The inquiry panel found the defendant guilty of misconduct in a professional respect as charged, and that he had, by his conduct, fallen below the standards expected of registered medical practitioners in Hong Kong. I'll move on to talk about the Advanced Decision on Life-Sustaining Treatment Ordinance, which is a piece of new legislation. This ordinance also relates to mental capacity issues. The bill of this ordinance was gazetted in 2023. In November 2024, the Legislative Council enacted the Advanced Decision on Life-Sustaining Treatment Ordinance, the ADLTO. This ordinance has not yet come into operation. The government indicated that there is going to be a preparation period of 18 months. The ADLTO provides for the making, operation, and revocation of two advanced decision instruments, namely advanced medical directives and DNA CPR orders. Actually, before the ADLTO was enacted, the practice of making and using advanced medical directives and DNA CPR orders had existed in Hong Kong, and years ago, the Hospital Authority issued guidelines on advanced medical directives and DNA CPR orders. However, the lack of a legislative framework resulted in considerable uncertainties. The commencement of the ADLTO will get rid of these uncertainties. I will talk about advanced medical directives first and then DNA CPR orders under the ADLTO. An advanced medical directive is essentially an instrument in which an adult specifies, when mentally competent, what life-sustaining treatment he or she would refuse at a future time when he or she is no longer mentally competent. Let's look at the legal definition of advanced medical directive in the ADLTO. In the ADLTO, the definition of an advanced medical directive is an instrument made by a person that contains one or more instructions that, if that person is mentally incapable of deciding on a life-sustaining treatment and the specified precondition of the instruction is met, the person is not to be subjected to any life-sustaining treatment specified. At the time when a person makes an advanced medical directive, he or she must be an adult and mentally capable of deciding on a life-sustaining treatment. In other words, an adult who is mentally capable of deciding on a life-sustaining treatment may make an advance medical directive to specify that if he or she is mentally incapable of deciding on a life-sustaining treatment and the specified precondition in the advance medical directive is met, in that case, he or she shall not undergo any form of life-sustaining treatment specified in the advanced medical directive. For example, an advanced medical directive may specify artificial nutrition and hydration as the form of life-sustaining treatment that the person shall not be subjected to. The ADLTO defines specified precondition as the condition precedent that is specified in the directive for following the instruction. For example, a person may specify being terminally ill as the only specified precondition for following his instruction of no life-sustaining treatment. In that case, his advanced medical directive instruction will not apply unless he is terminally ill, in addition to being mentally incapable. Advanced medical directives made under the ADLTO must meet the conditions set out in sections 9 to 12 of the ADLTO regarding legal capacity, form, signatures, and witnesses. There are 2 model forms for advanced medical directives in the ADLTO, but it is not compulsory for an advanced medical directive to follow the wording of the 2 model forms. I have set out here extracts from model form 1. The extracts here are a very small part of the Advanced Medical Directive Model Form 1, which is a much longer document. The extracts state that I understand that this directive applies in relation to my medical treatment only when I am mentally incapable of deciding on a life-sustaining treatment. If I am terminally ill, my instruction is as follows. I am not to be subjected to any form of life-sustaining treatment. By putting a tick in the box at the top and the box circled in blue, the subject person, who is referred to as the maker in the ADLTO, made being terminally ill a specified precondition such that if he or she is terminally ill, in addition to being mentally incapable of deciding on a life-sustaining treatment, he or she shall not be subjected to any form of life-sustaining treatment. Alternatively, the maker could have taken the boxes circled in red instead of the box circled in blue so that his or her instruction will be, I'm not to be subjected to artificial nutrition or artificial hydration. The maker may, in addition or in the alternative, take the second last box so that the Advanced Medical Directive will state that if I am in a persistent vegetative state or a state of irreversible coma, my instruction is as follows. In which case, being in a persistent vegetative state or a state of irreversible coma will be a specified precondition. The maker may also take the last box and put down the name of another end-stage irreversible life-limiting condition so that the end-stage irreversible life-limiting condition that he or she specifies will be a specified precondition. If the maker does take the second last box and the last box, the maker will have to indicate the form or forms of life-sustaining treatment that he or she would like to refuse. If he or she is, in addition to being mentally incapable, in a persistent vegetative state or a state of irreversible coma, or in another end-stage irreversible life-limiting condition specified. As mentioned, it is not compulsory to follow the wording of the model forms. I included the extracts of Model Form 1 on this slide just to show what an advanced medical directive might look like. At the stage of making an advanced medical directive, the subject person, who is referred to as the maker in the ADLTO, must sign the advanced medical directive in the presence of at least 2 witnesses, and one of the witnesses must be a registered medical practitioner. The witness, who is a registered medical practitioner, must, among other things, be satisfied that the maker is mentally capable of deciding on a life-sustaining treatment at the time when the maker signs the advanced medical directive. The second advanced decision instrument under the ADLTO, as mentioned, is the DNA CPR order. DNA CPR stands for Do Not Attempt Cardiopulmonary Resuscitation. Before I explain the nature of a DNA CPR order, I would like to quickly explain what cardiopulmonary resuscitation means. Cardiopulmonary resuscitation, CPR, is an emergency life-sustaining treatment that is performed on a person in cardiopulmonary arrest and aims to restore or maintain blood circulation and oxygenation to his or her vital organs. Cardiopulmonary arrest is a medical term. To put it in simple words, if a person is in cardiopulmonary arrest, that means effective ventilation and circulation in that person has stopped. A DNA CPR order is an instrument that has a continuing effect and directs not to perform cardiopulmonary resuscitation, CPR, on the subject patient when he or she is in cardiopulmonary arrest. Essentially, a DNA CPR order is an order that CPR is not to be performed on the subject patient when he or she is in cardiopulmonary arrest. The initial effective period of a DNA CPR order should not exceed 1 year. For each extension of the effective period, the extension should not exceed 1 year either. In contrast to an advanced medical directive, a DNA CPR order must be in one of the prescribed forms, and a DNA CPR order is not made by the person who is the subject patient. Instead, a DNA CPR order is made by 2 registered medical practitioners. One of these 2 registered medical practitioners must be a specialist. A DNA CPR order must certify that the subject patient is already in at least one of the following 3 conditions, namely terminally ill, or in a persistent vegetative state, or a state of irreversible coma, or in an other end-stage irreversible life-limiting condition. The ADLTO provides for 3 types of DNA CPR orders. The first kind is based on an advanced medical directive. The second kind is not based on an advanced medical directive and is made for an adult who is mentally incapable of deciding on a life-sustaining treatment. The third kind is not based on an advanced medical directive and is made for a person who has not yet attained the age of 18 years. The government contemplated that DNA CPR orders will be invoked in both hospital and non-hospital settings.
Thank you, Jane, and thank you, everyone. Have a nice evening and Merry Christmas in advance. Yeah, okay, thank you.